Appreciate westbound approaching the CW extension, or are you actually in the Northgate Village apartments now?
Well, I can tell you it's been a very, very dangerous and extremely fast pursuit. They've been chasing that van right there. Now,
It's exactly what he's doing. Are you Googling the laws right now?
Henderson Police Department's SWAT team responded to the scene and set up a perimeter around the condominium.
I travel in and out of time zones.
And the 3 key rules for a criminal defense lawyer: always on time, impeccably dressed, and occasionally sober.
The yellow sports car up ahead won't stop. Then something happens you might expect in a Spider-Man movie. It wraps around the tire of the fleeing vehicle and stops all forward motion.
Objection, action answered.
I mean, he leaps over the fucking bench.
No, the thing is, that's my property. You have no choice.
Actually, I do, because I found friggin' Xanax bars on your driver's seat. If you want to explain something, explain those.
Cops get very frustrated when you don't answer their questions.
No.
Right, step back forward.
He's gonna go straight. There's a car right here. Got him.
All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom.
This is fucking hilarious. So he pulls out a joint in court.
Go, 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 go.
Turn on your stomach! Stop fighting us! Stop resisting!
The injury by the police, that may be a separate issue for you to file a civil suit.
Chris, just while he's doing that, talk to me. What were you running for again?
Warrant.
Warrants? A felony warrant, city warrants, what?
Felony warrant on Kansas.
Well, I'm pretty sure they ran you, and you don't have any warrants.
I don't.
No.
No warrants.
No. So all that for nothing, right? No warrants, no nothing.
Yeah.
Police! A little farther, bro. A little more. Okay, go.
Not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
We're there, guys. Got eyes on.
I want to suck. Yes, I think I would like to suck your dick. I don't think so.
I prefer not to.
I prefer not to, sir. See that? I love that.
So do you wish to say anything?
No, ma'am.
All right, thank you.
Hello, good morning, good afternoon, hello. We're back. Yeah, we're back. And it feels like forever. Feels like an eternity that I haven't been here with you all. And I know you don't have to tell me. I know you missed me. This much. Well, how did we all have a good weekend this weekend? All rested up? Welcome to Monday morning. Bright and early. Well, maybe for some, not for me. But you get that when there's a time difference between here and the US. So, thank you very much for joining us. Welcome in. I'm still just waiting to hear back from Stephen from Justice is a Process. As you saw on the thumbnail, his plan is to join us today, and he may jump on at some point throughout the stream, but not 100% sure because there's a possibility that his wife may have gone back into early labour again. So we'll keep our fingers crossed, and we'll hope that she keeps her legs crossed because Bub's still about 6 weeks early. Little Carson. So our thoughts go out to him, and hopefully everything is good and controlled, and he can jump on and join us. Otherwise, you're just going to have to put up with moi. And I'm sure we'll manage somehow. We'll work it out. So I don't know how many of you caught Steve's live last night. He went through a few of the new documents that have dropped in the Tyrone Tucker case. In particular, there is the I think it's a motion to suppress Travis Johnson's testimony, a motion for show cause for Todd O'Quinn, and I think it's a motion to dismiss or something. I'll go through them anyway, one by one. So, a little bit of a quick update. Ty has, as I said, I think he's put in a motion to dismiss, which is set to be heard on the 2nd of August, and his trial is still set at this point for the 6th of September. Now, he has been appointed defense counsel. So he has applied for, I think it's called criminal indigency. I think that's how you say it. So he's been appointed a public defender, and there are some concerns that he may not keep his counsel, which in speaking with Steve about this, and you'll see on his, I've got some snippets of his live from last night if he isn't able to join us, but his concern is that if Ty continues to want to represent himself and turn down this public defender, then the state basically almost tie his hands then for the appellate process, because he can't then appeal on ineffective counsel because he has turned down his public defender. So if anyone is in contact with Ty, can you please beg him to keep this public defender on, even if he is the biggest boob out? Just make sure he has some representation, because they know the way to get the evidence in that needs to come in to create reasonable doubt. And that's what we need to get Ty out of this conviction. Otherwise, they're going to throw everything they have at him, sew him up in a bag and piff him away. And this is an innocent man in jail, and we need to try and do as much as we can, which is the second reason I'm doing this live stream, trying to create some more awareness, trying to get other content creators to pick up the story again and get it back up and running and noticed by everyone, so that Ty can have some support, because he's in there on his own, dealing with it on his own and struggling. So he needs all the help that we can give him. And at the end of the day, Karen Reid was factually innocent, and so is Tyrone Tucker. So we need to remember that. There is absolutely no evidence whatsoever to tie him to this crime, and he is 100% innocent, and he needs our help. So feel free to share this video. You can share bits of it, all of it, whatever you like, onto wherever you want to, just to get the word out there, because we're now, 6 weeks out from trial, and he needs our help. You're going to try and talk to him today, Christine. That would be great. I've been trying, and I keep the telecommunications company that they use for the prison system down there, it won't verify an international number. So I contacted them via email to try and get a verification SMS back to me, so that I could, because I've created the account, I just can't utilize it until it's been verified, and they won't accept emails from international callers, and they won't accept international ID. So I can't say I didn't try. So yes, if you get hold of him, Christine, if you could pass that message on, that would be amazing, because it's really, really important for Ty's future that he keeps this public defender 100% keeps him to represent him, because he'll cut his nose off to spite his face, unfortunately. Oh, he tried to call you and you missed the call. Bugger. I might try and I'll speak to you offline, and I will try and send some money over to you and piggyback off you, perhaps. Maybe we can organise it that way. Anywho, whilst we're waiting, let's have a look at this motion. Now, the state are basically, from the very start, they have done nothing but be underhanded and dirty, downright dirty. And the amount of things they have done to suppress both his voice and his evidence are equal to none, basically. So they initially, at the first trial, they struck a deal with John Travis Johnson so that he would testify against Ty. Good morning, Bri Bear. How are we? Lovely to see you. And yes, better late than never. Welcome and thank you. You missed out, I'm still waiting to hear back from Steve. He sent me an email overnight saying that his wife may have gone back into early labour. So it was a bit of touch and go whether or not he could join us. But otherwise, I've got some snippets from his last night's live, and I've got the documents also that he went through that we can also do. And you'll just have to put up with moi. I know there's probably a lot better things that you could do. Trust me on that. Right. So, yes, John Travis Johnson. So they he took a plea deal and testified against Bri. That testimony has apparently since been redacted, and now with this trial, they're trying to suppress that testimony coming in under marina violations. Yeah. So not only are they suppressing him and gagging him by incarcerating him so that he can't speak to anybody, he can't access the media, he can't get his voice heard so that he can generate some media support. But they are also tying his hands in every way that they can. So, and this public defender, it's Stephen's inclination to think that it's the state's last-ditched attempt to, because knowing that Ty is so stubborn that he will fire his public defender, and that will then seal the deal with appellate issues, because he then can't appeal for, he won't know how to preserve the record for a start. He won't know how to preserve it effectively, and he won't be able to claim ineffective counsel as a pro se. So it's imperative that he keeps this public defender. Can I call the defence attorney? No, I don't know who the defence attorney is. And as I said, I'm struggling to internationally to call anywhere over there. So they won't even email me back. So I do know that they have the public defender's number on the Monroe County Clerk's office on their website. If you look up Ty's case number. Now, I have actually put in the description box all the ways that you can contact Ty, his website, his YouTube, his Facebook, to show your support. And if anyone wants the details on how to deposit money into his account or anything like that for his tablet, so that he can actually get onto the internet and receive emails, send emails, be they motions or responses to motions or whatever, let me know in chat, and I will send you my email address and give you the details. And I do know Steve was also trying to get in contact with him as well, and it's probably easier that someone from over there speak with him rather than me, because I think international charges will probably apply as well, even though it's internet based. So I've got a credit card, Christine. I've put all that in, but it will not even let me process that. I tried 3 times to deposit a payment into his tablet, and because I haven't verified the account, it just rejected it 3 times. So I can't even do that. I can send you money and you can transfer it perhaps, but we'll do that offline. So the other thing that the state is doing as well is trying to prevent Todd O'Quinn from testifying, because he's basically the last witness that can really provide the evidence that he saw someone, the white person out of the 2 assailants in the death of Matthew Bonnet, that removed their mask and it wasn't Ty. So he has a visual of the white assailant out of the 2 that performed the initial botched robbery back in 2017 in Key West at the Treehouse. Now, Judge Morgan too is on board. Mansfield is doing everything he can to keep his hands tied, and they're just trying to suppress as much as they can and stop him from getting in the evidence that he needs to get in to create that reasonable doubt. So without that, we'll go for this here. So this is a motion for order to show just cause. So Ty wrote this on the 9th of July. Okay, so comes now pro se defendant Franklin Tyrone Tucker moves this court to issue an immediate ruling and order to show just cause against the state. In support thereof, the defence would offer the following causes for granting such an order. 1. As was previously indicated in the defence motion to modify the no contact orders, actually, I shall go to that first. So this is the motion, the state's motion to modify the protective order. So basically what happened is, jumping back again, is that at the first trial, the state put in a protective order against, there was a few of them. There was Tyrone, there was John Travis Johnson, I think, Rory Wilson, Todd O'Quinn, at the very least those 3, so that Ty could not have contact with them because they were co-defendants. But the state have also put in a motion leading up to this trial to have this gag order reinstated and extended, which then prevents Ty from actually subpoenaing and questioning his prime witness, Todd O'Quinn. So that's what they're trying to do. They're trying to keep this gag order going so that Ty cannot have called Todd to the stand. So that's what he's referring to in this. And of course, it's the smallest writing. Let me see if I can increase that a second. All right. Plaintiff, State of Florida, by and through the undersigned Assistant State Attorney, moves this honourable court for the issuance of a protective order to prevent extrajudicial comments in the above-styled actions. As grounds, the state would show as follows. This matter is currently pending before this honourable court. 2. A concern for both the plaintiff and defendant is whether a fair and impartial jury can be seated. The above-styled action has resulted in extensive pretrial publicity, both through traditional news outlets and web pages. So basically what they're saying is they want, because Ty opened his own YouTube channel and started speaking about the evidence that was suppressed, that he couldn't get into the first trial, and the alleged corruption and stuff down there, they are trying to shut him up, and he knows too much. They want to completely shut him up and keep him in jail now. They don't want him to say any more, because that will expose them all. And as we've learnt in the Karen Reid case, it's not out of the realm of possibility. And the other thing is, too, we learnt in the Alec Baldwin case, they've got these amazing defense attorneys who were able to find issues with the prosecution's case, and in doing so, managed to get Alec a dismissal. Now, A, Ty may not be able to know how to do that, to achieve that, and B, he probably doesn't have the tools to be able to find that without being able to access the internet and without knowing where to look and how to look for it, and then how to bring it in. It's an uphill battle. So, yeah. Number 3, they go into Lauren, specifically Mrs. Lauren Janai, the significant other of the defendant, has created a web page, blah, 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 blah. That's what I was just talking about. Next page is number 5. Florida rule of professional conduct, prejudicial, extrajudicial statements prohibited. So basically what they've been saying is that because Ty has put out all this information online, that they won't be able to have a jury pool that has not seen this information, and therefore they can't seat a fair jury. A lawyer shall not make an extrajudicial statement that a reasonable person would expect to be discriminated by means of public communication if the lawyer knows, or reasonably should know, that it will have a substantial likelihood of materially prejudicing and adjunctive proceeding due to its creation of an imminent and substantial detrimental effect on that proceeding. Could they think of any more big words? B, statements of third parties. A lawyer shall not counsel or assist another person to make such a statement. Counsel shall exercise reasonable care to prevent investigators, employees, or other persons assisting in or associated with a case from making extrajudicial statements that are prohibited under this rule. And they're saying that he is basically going against this rule. Counsel for the defendant has also made extrajudicial comments on Facebook regarding this case, blah, blah. The court must determine whether a restriction on extrajudicial statements is needed on a case-by-case basis. So they quote a heap of case law. The limitations imposed by the court on communications between the media and lawyers and or litigants must be for good cause to assure fair trials. Limitations placed upon lawyers, litigants, and officials directly affected by court proceedings may be made at the court's discretion for good cause to assure fair trials. Muzzling lawyers who may wish to make public statements to gain public sentiment for their clients has long been recognised as within the court's inherent power to control professional conduct. Rah. Okay, so basically, in other words, oh, hello. I'm sorry, I had to enlarge that screen and couldn't see chat. How are you, Angela? Welcome. So that is them trying to shut him up on paper, and instead, what did they do? They took something as simple as a late UNA screening test and ordered a bench warrant, put his bond at $3.1 million, and arrested him at the Oregon airport and put him in jail. Seems fair to me. not? Never mind. So let's go to this motion for show cause, shall we? So this is what Ty was referring to when he mentioned the motion to modify the contact orders. As was previously indicated in the defence motion to modify the no contact orders of state witnesses, in this case, victims' witnesses Todd O'Quinn has made clear his intention to testify for the defence at this trial. What does the bottom one say? 2. Okay. Yeah, it's under the unknown something or other. The states, blah, blah, blah. I can't see it. It's under my settings. Bugger. Let's go to the next one. Witness on March 25th, 2024, which required he be available to testify before this court at trial for the state. Number 3, the dates given to this witness to appear at trial were the weeks of May the 13th to the 24th and June the 3rd to the 14th, 2024. Number 4. Thanks, Gabby. What's that? Oh, you haven't been in our chats for a while, Angela. This is nothing. You need to go back and check out the the Witchcraft Mum chat. That was funny. Oh dear. So he's telling us that the state even gave Todd O'Quinn the wrong dates to appear for his trial. Unbelievable. Number 4, the state was aware the court scheduled trial to begin in September of 2024. Yes, well, we've got that on the docket. So this motion for show cause is set for a hearing, as I said, on the 2nd of August. Number 5. On June 13th, 2024, the defence received a copy of the state motion for an order to show cause against the victim witness for failing to appear to their faux trial dates. Now, I've got that as well. Number 6, this victim witness has stated many times in video interviews that I have to put it in a bigger screen. That he fears reprisals by the state for testifying truthfully for the defence. Number 7, the state is something aware that the testimony of witness is more, and I can't read it because it's again under my bloody instructions. No, I can't move it. Testimony. Number 8. The eyewitness not only has stated many times that it wasn't the defendant he saw that night running away from the crime scene. Number 9. In addition to his statements that it was not Mr. Tucker he saw that night, he also pointed out to a picture of the state's only material witness, John Travis Johnson, when shown a photo lineup. Number 10. Making matters worse for the state, he also totally contradicts the state's theory and Mr. Johnson's testimony in his first statements made to police by saying he saw the white suspect take off his mask while running down the street and then jump into a truck and take off. The testimony of this witness victim negates the idea that John Travis Johnson was just the getaway driver, as the state claims, and instead makes Johnson the second assailant, as all the evidence has always supported. Number 12. No, I need to sip. Oh, hot jambalaya. Whilst the state has the right to subpoena witnesses to legitimate hearings or trial dates, it does not have the right to abuse that power simply to harass victims' witnesses for the defence. 13. As the court is no doubt aware, the Florida Constitution contains a list of rights for victims of crime, commonly called Marsy's Law. Hopefully Steve does come on and he can explain what that is. One of these rights is to be free from intimidation, harassment, and abuse. Okay, and he cites case law there. 14. The defence would submit that this law applies equally to the state as it would to the accused. 15. This is not the first time the state has abused a victim in the case because they wanted to testify for the defence, or the first time the defence has had to cite Marsy's Law in order to protect the rights of victims in this case. I think he's referring to Paula Belmont there. 16. At the first trial, the state and court tried to prevent a victim, Miss Paula Belmont, from testifying for the defence. She was gravely ill and in the hospital, and once again the defence had to argue Marsy's Law, which allowed her to testify via Zoom. However, when her condition got worse and the defence made an emergency request to let her go out of turn, both the judge and state mocked her illness, accused her of faking, I think it says, and it ended with the judge making a disgusting ruling that even if the defence produced a doctor's note saying she was dying, he would not let her go out of turn. So after being mocked and called a liar by the judge and state, Miss Paula Belmont passed away on February the 6th, 2024, less than 2 weeks after the trial. And rest in peace, Paula. 17. In his public statement announcing his intention to retry this defendant, the state attorney, Dennis Ward, made the horrendous remarks that he was doing it for justice for the victims. He even named Miss Belmont in his loathsome rhetoric. In reality, the only person who has fought for the victims in this case is the defendant, whose tolerance for the state and court's rancid behaviour, especially towards the victims, is most definitely at an end. If the court and state want to forego this fake trial, throw a rope over a branch and have this be done, then fine. However, stop treating the victims in this case as if they're the criminals just because they won't help you tie the knot. 18. The defence is fully aware that the defendant is not a licensed attorney and he is only allowed to make arguments in this case that would include any motion filed in this case, including the state's motion to show cause. Equally, the defence has the right to protect its witnesses and a duty to remind the court to protect the victims in this case. As such, the defendant is not acting as an attorney, but an innocent man who has been forced to defend himself, a moral man asking the court to defend those that he cannot. Wherefore, the defence requests the court to deny the state's motion and instead issue an order for the state to show cause for its blatant harassment of a victim and witness for the defence. If they cannot provide just cause, then the defence would request they be barred from issuing any more fake subpoenas and a no-contact order be issued against the state to protect this victim from further harassment. I hereby certify that a true copy of this foregoing was sent to the state via Program Services at the Monroe County Detention Centre on the 26th of June 2024. Well, there you go. Oh, Marsy's Law. Thanks, Bri. Ensures that victims of crime have equal constitutional rights on the same levels as those accused and convicted of crime. Awesome. Thank you. Thank you. So that is that one. Now, let me see. I'm going to bring up a video just to clip it from last night's live with Steve. So it doesn't look like he's going to be joining us. So let me put this up. Oops. That's not what I wanted. Go away there. Open. No, Stop it. Don't want to open it there. Open with. Thank you. Media player. I'll get there eventually. Whoop. Pause. Move you back up there. Share screen. I'll get there eventually. Don't you worry. One day. Present. Share screen. Window. That one. There we go. Oh, sorry. Bad pause. Bad pause, Steve. Sorry. Let's go. Oh, can't you? Really? Bugger. All right. Let me see what I can do about that. Can't hear it at all. Wonder if my boost will do it. Where'd you go? Where'd you go? Let's try again. Can you hear that? All right. Let me try and open it in something else then. That didn't go to plan, did it? All right, let's open it in there. See if that works. Go up there. Share screen. Window. This one. All right, tell me if you can hear this one. Oh. All right. I'm just going to have to go to his. I'm just going to have to share his screen then, aren't I? Bear with me. My apologies. I saved 4 awesome quotes from his stream. I thought I did a really, really good job. Stop it, you stupid machine. I don't like computers. Sorry, computer. I love you. Just play nice. Play nice. Shit. Justice is a process. Where are we? Yeah, he should be here helping me. Then you would hear him. Oh, that's me. I just brought up my own my own video. Dickhead. Oh, Lord. Go again, Jody. Justice is a... Start again. When you search for justice is a process in your own YouTube channel, it comes up with your own videos, apparently. Who'd have thunk? Okay, justice is a process. Hello, Mr. Steve. Okay, lives. There we go. Nope, that's not the one. Is it? Oh, that's 10 days ago. 22 hours ago. Here we go. Let me just find the spot. Okay, here we go. We're up and running, cooking with gas. Now, hopefully you can bloody well hear this. Okay. Share screen. That one. Share. Hello. Recognize this face? Let's do it.
It's concerning because, again, we see this case differently because
Can
we've
you hear
seen
that?
all the other evidence, or we've seen a lot of the other evidence. We've seen the Todd O'Quinn tapes. We've seen the fact that there is no evidence. We've seen.
Can you hear that? Can you hear that? Yay! Thank God.
Penny Phelps come into the evidence room and interject herself into the interrogation of John Travis Johnson. We've seen the tapes of Paula Belmont after the fact at the hospital, but the jury will see none of that. All the jury's going to hear is that this is a story about 3 drug users who made a decision to go try to do a quick hit and run, grab some drugs, and get high. John Travis Johnson, they're never going to see this guy on the stand. They're going to see it. They're going to hear his testimony. They're going to hear what he testified to in the previous case. And then they're going to go, okay, well, isn't it likely that Ty would have done, be involved in this? Well, yeah. And they're going to hear inconclusive. The state's going to make the argument that only Ty Tucker could have known because of the blood on the handle, which we all know that's not true because Ty was told in his own interrogation that blood was on the handle, from Matt Bonnet because it was the knife used to kill Matt Bonnet. So, and that they believed Ty's DNA was on that because he was the one. Ty said, wasn't me. So we all know that Ty was told this information by Penny Phelps, which he communicated to Paula, but they misrepresented it in the first trial. They're going to try to misrepresent it in this trial. And Ty is going to be unable to adequately defend himself when you have, in the concern I have is this: they are not going to follow the rules because Ty, they already know, or at least they're anticipating, unless Ty changes his tactics, that he isn't going to be willing to make a record because Ty, as he's told me, as he's told others, he isn't in this for an appeal, although he should be. And the state knows that you have no claim for ineffective assistance of counsel when you're pro se, because it's made clear that you're taking the risk of defending yourself, and therefore you can't go back and say I was ineffective because I didn't know the law or didn't understand what I was doing. You took that on yourself. You chose not to hire an attorney, or in this case, he's choosing to not take his appointed counsel. So they're going to be emboldened, as they've already been, and like never before, that when they get to that trial, they're going to do anything and everything. These guys are going to pull every dirty trick out of the basket at the back of their hands, and we're going to have to be watching very closely. And Judge Morgan, who has demonstrated that he was willing to revoke his bond for no reason. Yeah. He was willing to
How many times have you guys sat and watched, Judge Boyd and someone's come in with a bond violation or a parole violation and, she's given them a talking to and, a stern warning and sent them on their way. Whereas, Ty was on pretrial release for what, 4 years? And no issues. And alcohol was not an issue in the case. And yet he was late to his UNA screen, which he did do and passed. And they issued a bench warrant straight away. What does that tell you?
He's willing to join the state in hiding Todd, trying to keep Todd Quinn out of the case. He's willing to we haven't seen the ruling yet, but I mean,
the other thing I wanted to point out too, if you can see on the screen here, can you see my cursor? On the back there, he's actually on the Monroe County Clerk's office. And this is a listing of the upcoming motion hearing. So we've got one on the 1st, which is basically just a status hearing. Then we have the hearing for the motion of just cause, and then the next one is the trial. But then if you look down below the motion in limine, there are 4 different things that have not, they're in there, but the actual little symbol to the right-hand side, see how it's got a green page or a clock? Those clock symbols refer to them awaiting redaction. So they are redacting these 4 documents here before they upload them onto the Monroe County Sheriff Clerk's office. As Steve was going through last night, they redacted a fair bit from one of Ty's motions as well.
Anticipating he's going to rule that none of the IA report, no evidence of misconduct can come in. They're going to use that to keep that out of the trial and keep Ty Tucker from going into it. I do believe they're going to attempt to try to keep the motion to suppress that was filed by Seth LeVay on behalf of John Travis Johnson out of the case. And Ty I don't think is going to know how to get it in. They're going to do all these things. They're going to essentially gut the ability for Ty to have a case, or at least a case that he wants to present. And by the time we get to trial in September, Ty is going to have been worn down by spending 4 months in jail in the summer months. And it's going to be rough. So Ty, what we need here is a lawyer to get involved. And it looks like we have one. So it appears for the time being that if you have a way of talking to Ty, if you can get in contact with Ty, please encourage him, if he gets appointed a public defender, to let that public defender take over his case, because they will know how to utilize the motion to suppress to impeach John Travis Johnson. They will know how to keep out the parts of Paula Belmont's testimony that shouldn't come in. They will be able to get it in the pieces that need to come in. They will be able to limit what the state can do as far as what they're doing with the argument they're going to make in regards to the blood on the knife. They're going to be able to keep that out. They're going to be able to get pieces of the statement in. They're going to be able to ensure that the jury understands that there is no evidence to link Ty Tucker to this case. They may even be able to subpoena certain people. Like, I believe they should be subpoenaing Gabby, the individual that called 911. She needs to be subpoenaed and brought in. William Alexander needs to be brought in. We need to have in Officer Blake needs to be brought in. We need to have these people on subpoena and ready and brought in. Matt Pitcher needs to be brought in to testify. So again, as we are, and that is, I've got it ready. I've pretty much got everything prepared to play the deposition in full on Matt Pitcher. We're going to do that. It's going to probably take, it looks like, about 5 hours to do. So we're going to do that here. I've just had a lot of personal things going on right now that I haven't been able to get it scheduled to sit down for 5 hours and do that. We're going to do that, and you're going to see why Matt Pitcher's testimony is so important.
If if he can't do that, if it comes to it, which I think it might have, because I haven't heard back from him. I've just checked my emails again that his wife may have gone back into early labour. If he can't do that, I do have Detective Pitcher's full deposition, and it is really lengthy. So if you're interested in that being read to you, if Steve cannot manage to do it over the next week or so, we'll organise it. Okay.
And you're going to really hear all of the problems in this case. And you're going to hear a little bit in a few minutes when we start getting into the motions that Ty Tucker has filed. You're going to get to hear some of the things that Ty Tucker would be able to raise by introducing Matt Pitcher's testimony. But these are the things that a good defense attorney can do, because why? You put these people on the stand. You have Gabby, who testifies about the car. She saw someone jump out of the house, run out of the house, and get in a sedan. Was it a sedan? Was it a truck? William Alexander says a sedan pulled up, bloody sweatshirt. Where's the bloody sweatshirt? We need to get the, I can't remember the other officer that was on there who can testify to what they didn't do, that they didn't go down and investigate, that they, that he talked to someone and that there was talks of two men fighting down by the hogfish. They can make sure Todd O'Quinn shows up, and they can question him about what he saw, and he can raise doubt as to who he saw, that he saw John Travis Johnson run out, not Ty Tucker. By the time you get done, these witnesses are able to raise doubt as to who was there, who was what, and whether the state knows anything at all. You can bring in and make sure that there's Officer Malone or Detective Malone is questioned correctly on why the videos were not properly.
Yes. So the videos from Keys Marine, which is directly opposite the treehouse, which had the most opportune camera right there in front of the treehouse. Apparently, they asked for the incorrect day, and by the time they realised that they'd gotten the wrong videos, it was too late to retrieve the ones from the actual day, and that happened on the CVS, the big pharmacy across the way as well. So when we went round and did drop the pin and had a look at all the cameras in the area, there was at least 1, 2, 3, 4, 5, another 6 cameras that they could have had perfect viewing of who came and went into that treehouse from the front and not from under the rear canopy of the Marine place.
Handled and how they got lost, and why the CVS videos weren't collected properly, and they were lost and they were collected on the wrong day.
Funny that
all these things can be handled.
Is this all starting to sound a little bit familiar, like Karen Reid and the Sally Port videos and Canton Police investigating? And this isn't out of our realm of possibility. It's been proven now that there is corruption right the way to the top. Right the way to the state attorney's office. And this is no exception. So it needs as much traction as we can give it, and as much as deserving as Karen Reid. The fact that she's able to afford, some highfalutin defense attorneys doesn't make her any less in need of a fair trial. Everyone is entitled to that. Everyone.
And brought in, and by the time it gets to the jury, a public defender is going to be able to get a major victory on, in their career, because they're going to be able to absolutely tear apart the state's case. So I hope that what we find out here is that the public defender's office takes over this case, that they request a continuance, and that we get at least a continuance maybe into October, so that they can have the time to adequately prepare the case, subpoena witnesses, and get this thing rolling. But we shall see. But our dream is here. Now, what I believe happened here, guys, and this is what I'm scared of.
This is the really important bit. This is why Ty needs to keep his public defender.
Scared of the outcome to come, but I'll talk about what I think happened. I can't help but believe that we were, I think it was back on the 11th, I had put out a, episode 21, and I made it very clear that I believed that the state of Florida, and it was a very serious accusation, that the state of Florida was attempting to keep Ty Tucker from getting an attorney, from having an attorney to represent him. So I can't help but wonder if this, when he filed for indigency, if this isn't an attempt, because again, what they are trying to do in this case, and I believe Jimmy Morgan was brought in to do this, and I've said this from the beginning, what they are trying to do is get an ironclad verdict in this case that is unreversible on appeal. Mm-hmm. One of the things that could have possibly been raised by an appellate attorney would have been the idea that they went in, they revoked this man's bond, he ends up getting divorced by his wife because of his wife's socioeconomic situation, and because she's got, money, that they use that to block him from getting appointed counsel. And then as a result, he shows up and he's forced into a pro se situation this second time around, an issue I was raising and making. So it's my belief that what the state of Florida is doing right now, what they've done, because it was like he files for indigency, and what do? They go ahead and appoint him a public defender, because what they're inviting him to do is to do what I was told he's already told someone he's going to do, which I think is an absolutely devastatingly stupid move. And I believe what they want him to do is fire his attorney. By firing his attorney this time, it will absolutely remove any claims later that he was denied counsel. And that would have been one of the final vestiges of reversing this case that he could have possibly had later on down the road if he finds himself.
He's absolutely amazing. He is a walking Tyrone Tucker encyclopedia, and his analysis and knowledge of the law and how it works and his insight into it is just phenomenal. Phenomenal. I take my hat off to him and my earphones.
Self-convicted at the end of this thing. If he removes counsel, fires them, and then proceeds forward.
And he's a downright nice bloke too.
He is now fully owning the outcome of this case. And if he fails to make a record for the appellate court, if he fails to make a record for an appeal, then anything that they do that's wrong, that's incorrect, that's against the rules, that's corrupt, it can never be challenged. Because appeals courts are very, very clear on the fact that if you fail to make a record, you cannot raise that issue on appeal, regardless of how wrong or against the law it was. And since he's not an attorney and he's pro se, and if he fires his attorneys, makes the decision to go pro se, he removes ineffective assistance of counsel. One of the things Ty doesn't seem to understand is that if he allows the public defenders, even if this public defender comes in and is a complete incompetent boob, right? And they go in, but if his attorney is handling the case and his attorney...
He said boob. Boob.
He fails to do something, or fails to put up an adequate defense, fails to protect the record, fails to raise an issue, all of those things can be raised later on as ineffective assistance of counsel, in effect getting him a new trial. What Ty fails to remember is that until he's convicted, things like the Innocence Project and stuff like that will not look at his case. They sometimes will, but most of the time they're not going to. But if he gets convicted, the Innocence Project can come in. They will take on his case for appellate purposes, and then they can try to get the conviction reversed like they did in the Adnan Syed case, and they can go in and potentially even retry the case with the resources of the Innocence Project. And remember, my father was part, and again, we donated proceeds for for his death. My dad was part of that. He worked with them. He handled, this was something that intrinsically we've been, I'm familiar with. So for Ty to, I understand that he's brought attention to his case now, but it is imperative for the strategy, for him to see. And if somebody's talking to him, and again, I haven't had a chance to be able to get in contact with him. I have not been able to do that, but he needs to understand that it is absolutely imperative that he has an attorney with him, even if this attorney is the biggest boob and dumbass in the world, because it is that is a potential avenue later on, if they are really, really bad, that he can raise that issue, because his case, even, is going to eventually get attention, because eventually the Innocence Project will take a look at this case, and anyone who starts doing a deep dive in this case, like we have, like I have, like others have, is going to immediately see the problems within this case, and we're immediately going to be able to see this is an innocent man, wrongfully convicted, who deserves to have who will deserve to have the case overturned. But what Mansfield and company are trying to do is they want to eliminate any possibility that it could be overturned. Any possibility.
And why? Because he knows too much. He can out them. He has all the tickets, all the receipts. Just go onto his YouTube channel and have a look for yourself if you don't believe me. Yeah. I'm gonna cut that and just have Steve saying boob, 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 boob over and over again. Just like this one. Yeah, Gabby. This one's for you. Where is it? I think I emailed it to you today. Yeah.
Touche. Mm-mm. 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 Mm-mm.
I love Fleischer.
That there's any appellate issues, and it's not that there won't be, it's that he won't have properly preserved the record. And the last thing that they needed to do to ensure that was correct was they needed to make sure they needed to get a counsel appointed to him, have him fire counsel, and effectively waive that issue on appeal. So I believe, listen, these guys, this is the most dastardly, dirty people I've ever seen. These guys they're playing chess, and Tyrone Tucker's playing checkers. He's playing checkers because guess what? He doesn't know how to play chess right now because he's not a lawyer. So he's got to get that help, and he's got to get that assistance. Now, with that said, we're going to go through some of these motions. So the first motion I want to go through.
All right. We can get out of that because I have the motion right here. Motion in limine to exclude John Travis Johnson's motion to suppress pleading. Let me just get rid of that so I can read the bottom all the way to the bottom of the jar. All right. Now let me big screen it because I'm blind. The state of Florida respectfully requests this honorable court to order that the motion to suppress pleading filed by Travis Johnson's attorney, Seth LeVay, specifically the arguments, any alleged factual assertions or comments contained therein, is not to be mentioned or even referenced in the trial of this matter. In support, the state submits. 1. During the first trial, the defendant attempted to enter into evidence the actual motion to suppress pleading Travis Johnson's attorney, Seth LeVay's, authored and filed back on April 18, 2020. This motion was never set for an evidentiary hearing nor ruled upon. This pleading was not a sworn motion, i.e., Travis Johnson did not swear to any of the statements or assertions found within the motions. Number 2, it was cleared from what the defendant was attempting to do that the defendant believed that the pleading authored by Mr. LeVay could be used to impeach Travis Johnson's trial testimony. The presiding judge at the time advised the defendant such was not permitted. Moreover, Travis Johnson indicated at the first trial he was not aware of the motion his attorney had filed. 3. The state seeks this court to issue an order prohibiting the defendant from attempting again to use any information found within the motion to suppress to impeach Travis Johnson's trial testimony or to refer to any information found within the motion. The defendant is under the belief that the pleading authored by Mr. LeVay can somehow be attributed to statements of Travis Johnson and or that the pleading having been filed by his attorney, it can be deemed as having been adopted by Travis Johnson. There is nothing in term of applicable statutory or legal authority that supports what the defendant was attempting to do in the last trial, and an order precluding any attempt is requested. Wherefore, the state of Florida does hereby request that this honourable court grant the state's motion and order that the defendant not mention anything regarding tampered evidence directly or indirectly. In other words, shut up. Pretty much, shut up. So they are coming at him every way they possibly can. And I just hope he has the common sense to not fall for their trap like he did with the, waiving his right to a speedy trial. So, hopefully, we can get in contact with Ty and reiterate these concerns to him. Hopefully, we can generate some attention to this case. He is no less deserving than Karen Read or anyone else for a fair trial. He's sitting in jail with his hands tied, with his mouth gagged, pretty much, rhetorically speaking, and not being allowed to do anything. He can't produce his own defense. He's got lack of the utility to be able to do it. So even more reason he needs this public defender. So, I mean, there's so many similarities that I can compare between his case and Karen Read's case. The 2 minutes missing in where was the 2 minutes missing? Oh, in the cameras from the city library. 2 minutes missing in the middle where Karen would have passed by and her tail light would have been clearly seen. Well, there's 2 minutes missing in John Travis Johnson's testimony where they were trying to convince him to take a plea deal. Then miraculously 2 minutes disappears and the next thing he's accepting said plea deal and pointing the finger at Ty. It's they have put jailhouse snitches into the jail cell with him and tried to elicit wrongful testimony. I mean, the attorney, Carol Dunn. Was Carol Dunn? She was suspended for 15 months because of inappropriate behaviour. And now the district attorney, or the state, have rehired her again. Now, I don't know if she's been allocated to this case or not, but you can bet your bottom dollar she's in there in the background somewhere with her finger in the pie, so to speak. So, well, it looks like Steve's got his hands full, unfortunately, which is a shame, but we shall reschedule that when things settle down for him. And I hope that everything is okay over there. So I don't really have anything else to report unless you guys have any questions or anything else. I know that the Karen Read, there is another hearing today. This is her status hearing, isn't it? Today for what they're going to do with the jurors and whether or not the state are going to retry the case, I believe. So I'm not sure. Is YouTube is is it on court TV? Does anybody? What's the time over there now? 9:40 a.m. So the hearing probably would have started, I would have thought. Let's have a look. Court TV. We can have a quick jump over there if it's on. Oh, and the other, we did the 2 days of the witchcraft mum trial, alternate juror and myself, and the very end of the second day, after 6.5 hours of streaming, I had to go to bed because it was 4:30 in the morning. So AJ did the rest of it, and the verdict came in about an hour and a half later, and he was found guilty on both counts. So if you're looking for an update on that, what's his name? Tyler Daisy was found guilty of first-degree murder for unaliving his mother, who apparently practiced witchcraft on him, and their family dog, Echo. And tomorrow, don't forget that the Black Swan murder trial begins. They had jury selection, or they're having jury selection today, so the trial starts tomorrow, and we are covering that together. So we look forward to seeing you tomorrow night with that. That should be a hoot. I can't see anything on court TV for Karen Reid, though. Let me just double check Law and Crime whilst we're here. I have got a wicked car chase, if anyone wants to watch that. Law and Crime Network. Lives. Yeah, no, they've done the pre-trial hearing, but no, nothing on Law and Crime either. Well, I can't help you then. Me sorry. Me not have. Oh, did anyone watch Judge Fleischer on Friday? He was going off. He had all of them coming out of the barrel, like all of his best work in the one episode. It was gold, absolute gold. All right. Well, I might have to call that a night. Thank you for joining us again. I will let you know if and when Stephen is up and about and right to come on as a guest speaker and impart his wisdom upon us. And again, yes, he said them all, Gabby, all of them. Within half an hour, they were all coming out. What was I say? Yes. Yes, sending him best wishes, and hopefully everything is hunky-dory over there and everyone is safe and healthy and well. So now that I've said that, I need to find my outro. So don't forget, shout out to Alternate Juror 1. Don't forget to like and subscribe over there. And Justice is a Process as well. Get on to his YouTube channel. And if, at the very least, like and subscribe, but send him your best wishes as well. All right. So with that, oh, did I delete my song? I think I did. Did I? Oh no. It's under videos, I think. All right. Toodaloo. Stay safe. Keep well. Love you all. Mwah. Bye.
Covering true crime and police arrest, where the judges move and the defense rests. Watching courts and trials, criminals at best, where the gavel drops and the defense rests.